Good afternoon. My name is Tawanda Hunter Stallworth, and I am the proud program manager of the Antiracist Development Institute at Penn State Dickinson Law, where we are building an anti-racist law school, legal academy, and legal profession. And it is my pleasure to welcome you all to our webinar today. We are situated on the unceded territory of the Susquehannock peoples, and as such, recognize their status as First People on this land, as well as the First Peoples and First Nations that stand in relation to it. We must also recognize the Indigenous children and adults from numerous distinct nations forced or coerced into the reprogramming camp established at the Carlisle Indian Industrial School, the educational institutions, for-profit institutions, social institutions, and public institutions in Carlisle derived substantial benefits from practicing white supremacy on these unceded lands. As well, these institutions in Carlisle relied heavily upon enslaved and otherwise unfree African-American labor, and profited from the sale of enslaved human beings to fund economic, political, social, and government activities. Accordingly, we must act to acknowledge and redress these breaches of humanity. The Supreme Court's ruling in the cases of Students for Fair Admissions v. Harvard and UNC led a journalist to ask President Biden if we were experiencing a rogue court. After a brief pause, the president responded that this is not a normal court. In that pause, the weight of the moment caused me to remember Dr. King's not so rhetorical question, where do we go from here, chaos or community? The Antiracist Development Institute is fortunate to join with you all and our panelists who will help us unpack that question and position us all to move in the only direction that makes sense for this moment, forward. Today's CLE webinar is first in a four-part series that explores the impact and implications of the Supreme Court's ruling and will track how institutions across the country have managed under its influence. Our panelists today, in order of presentation, include Jeff Dodge, Dickinson Law Assistant Professor of Law, Joseph H. Goldstein, Faculty Scholar, and Associate Dean for Academic Affairs. A talented academic administrator with nearly 20 years spent in legal education, Dodge has broad experience overseeing law school and university level offices of academic affairs, student services, international programs, admissions, academic success, career services, and more. He has taught and presented on topics in the fields of family law, LGBTQ rights, and education law. Dodge has served as chair of 3 AALS sections as an ABA accreditation site inspector and on the LSAC's National Diversity Committee. He recently completed 3 concurrent appointments as the director of the Clio Pre-Law Summer Institute. Jay Austin, Executive Director for Law School Admission Council, Reaffirming Individuals Supporting Education, better known to all of us as LSAC Rise Alliance, which provides leadership and professional development support to student-facing law school staff by focusing on how the lived narratives and layers of personal identities of law school staff can be influential in building and retaining a legal education pipeline that adds to the diversity of the legal profession. Prior to joining LSAC, Austin served as the Senior Associate Dean of Enrollment and Financial Aid at Rutgers Law School. He also oversaw admissions and financial aid at University of California, Irvine School of Law, as well as the Azerbaijan Diplomatic Academy, Pennsylvania State University School of Law, University of Pennsylvania Carey Law School, and University of California Hastings College of the Law, and was an admissions officer at Columbia University School of Law and Columbia School of Business. Bekah Saidman-Krauss, Dickinson Law Associate Dean for Admissions and Financial Aid. Saidman-Krauss is the 2022 recipient of the AALS section on pre-law and admission to law school's Spotlight Award, the section's highest honor, which recognizes an individual who demonstrates a sustained history of performing beyond their job responsibilities, seeking opportunities to support the development of the legal education profession, and working to create structural and systemic change in an effort to increase access to legal education and diversify the legal profession. She is also the section's 2023 Presidential Changemaker Award recipient. She is a co-author of Building an Anti-Racist Law School, Inclusivity in Admissions and Retention of Diverse Students, Leadership Determines DEI Success. Bryan Fair, University of Alabama School of Law, Thomas E. Skinner Professor of Law. Professor Fair has held several administrative posts at the law school and the university. At the law school from 1997 to 2010, he directed the University of Fribourg UA Law Cooperative Exchange. He served as the Director of Diversity and International Programs in 2007 and 2011 and 2012, and Associate Dean for Special Programs from 2008 to 2010, supervising international diversity and public interest programs. He also served as an Assistant Vice President for Academic Affairs at the university from 1994 to 1997. According to his prophetic work, written in 1997, Notes of a Racial Caste Baby, Color Blindness, and the End of Affirmative Action, the Constitution of the United States was a series of compromises between white male property holders, Southern planters, and Northern merchants. At the heart of their deal was a clear race-conscious intent to place the interests of whites above those of Blacks. In this provocative and important book, Fair, the eighth of 10 children born to a single mother on public assistance in an Ohio ghetto, combines two histories, America's and his own, to offer a compelling defense of affirmative action. How can it be, Fair asked, that after hundreds of years of racial apartheid during which whites were granted 100% quotas to almost all professions, we have now convinced ourselves that after a few decades of remedial affirmative action, the playing field is now level. Centuries of racial caste, he argues, cannot be swept aside in a few short years. Did I mention that he wrote this in 1997? Fair ambitiously surveys the most common arguments for and against affirmative action. He argues that we must distinguish between America in the pre-civil rights movement era, when the law of the land was explicitly anti-Black, and today's affirmative action policies, which are decidedly not anti-white. He concludes that the only just and effective way in which to account for America's racial past and to negotiate current racial quagmires is to embrace a remedial affirmative action that relies neither on quotas nor fiery rhetoric, but one which takes race into account alongside other pertinent factors. Championing the model of diversity on which the United States was purportedly founded, Fair serves up a personal and persuasive account of why race-conscious policies are the most effective way to end de facto segregation and eliminate racial caste. Did I mention that he wrote this in 1997? We have set apart some time today for Q&A. And so we invite you to use the Q&A portion of the Zoom chat to ask questions that will be asked toward the end of our program. As your moderator, I will make every effort to present your questions in real time to the extent that your questions are in the flow of the conversation. Otherwise, they will be held until the end of the program. If you are seeking CLE credit for your attendance today, you will receive an email following the program with an attendance and program evaluation form. And with that, it is my privilege and my pleasure to turn the program over to Dean Dodge. Thank you.
Good afternoon, everyone. I have been given the task of providing a constitutional law overview in a short 20 minutes. I feel like I couldn't start, if you can click to the next slide, I couldn't start but by taking a step back and looking at the larger framework for education in the United States first. As we start, I want to highlight, though, that law schools really have been at the center of legal fights around race, access to education, and admissions for a very, very long time. In fact, in 1938, in the state of Missouri, ex rel. Gaines versus Canada, the Supreme Court decided to favor Lloyd Gaines, a Black student who had been refused admission to the University of Missouri Law School. The case set a precedent for other states to attempt to, quote, equalize Black school facilities rather than integrate them. In 1948, there was another case coming out of Oklahoma that went to the Supreme Court that was held unanimously that a student could not be denied entrance to a state law school solely because of her race. In 1950, in Sweet versus Painter, the Supreme Court held that the University of Texas Law School must admit a Black student because it was far superior in its offerings and resources than the separate Black law school, which had been hastily established in a downtown basement. This role of law schools is significant as we turn to affirmative action and where we go from here. It's significant also because law schools really have a historical legal precedent on the books of fighting desegregation and fighting these causes. Brown versus Board of Education is where I'd like to start. It's a landmark case. I'm sure everyone here has heard of it, knows something about it. In short, it's a 1954 Supreme Court case in which the justices ruled unanimously that racial segregation of children in public schools was unconstitutional. Brown was one of the cornerstones of the civil rights movement and helped establish the precedent that, quote, separate but equal education and other services were not, in fact, equal at all, as it deprived the plaintiffs of equal protection of the laws guaranteed by the 14th Amendment. In short, segregated schools were inherently unequal. It's worth noting that while the final decision was unanimous, at first, the justices were quite divided on how to rule on this school segregation case, with the Chief Justice at the time holding the opinion that the Plessy separate but equal decision should actually stand. But it was after the passing of that Chief Justice in September 1953, before the case was heard, that President Eisenhower actually had to replace it due to his death with Earl Warren, then governor of California. This is significant because the new Chief Justice was actually successful in engineering the unanimous decision that we now know from Brown v. Board of Education. I pause on this point simply to point out that Brown versus Board of Education could have resulted in a very different legal precedent had one Chief Justice been different all the way through the process. I start here because this case, in my mind, is really the beginning of the domino on matters of affirmative action. Brown continues to really have an unrealized and unfulfilled impact on our education system and on society more broadly. In fact, there was immediate resistance to Brown with many governors and elected officials, not just in the South, I should add, right? In the South, though, they were literally and figuratively standing in the way of desegregation. The Little Rock Nine, Ruby Bridges come to mind. In addition, the Brown decision did not immediately change the hearts and minds of the public. In fact, in communities around the United States, white families moved to the suburbs to avoid this integration, to avoid desegregation in their schools. This white flight phenomenon transitioned much of the already baked in de jure segregation or legalized segregation in our society into a blossoming de facto segregation or segregation by common understanding and personal choice. It is the second form of segregation that continues to permeate our society today. In short, this fortification of segregation through de jure segregation is a fortification also of white supremacy. While it wasn't necessarily permitted by law, it grew as a social and cultural tool, leaving neighborhoods to move to other neighborhoods with people that look like you. This is significant as de facto segregation left many schools in now primarily Black neighborhoods unequally funded and in serious neglect. In addition, de facto segregation created new, more complex challenges to these desegregation efforts. Efforts, I should note, that are still today. Yes, you heard me correctly, nearly 70 years after Brown, still today at issue. As I share in my education law class, Pitt County in North Carolina just realized a unitary status in compliance with the Brown decision in 2015. And there are other counties and school districts around the country that are still under federal district court review. So much for the all deliberate speed required in the Brown v. Board of Education 2 case. All of this is important because the Supreme Court also ruled in San Antonio Independent School District versus Rodriguez that in order for a fundamental right to be recognizable under the 14th Amendment, it must be determined that such a right is explicitly or implicitly guaranteed by the Constitution. When evidence was presented to that court that the way Texas was funding its school system through property taxes, creating unequal resources for students, that court chose to say that it did not create systemic discrimination against poorer people on those grounds. The court said that the funding scheme was not, quote, so irrational as to be invidiously discriminatory. Since there isn't a fundamental right involved, any state action fell under rational basis review. Justice Powell in that case went further on to say that on the question of wealth and education, quote, the Equal Protection Clause does not require absolute equality or precisely equal advantages. This was in 1973, nearly 20 years after Brown. Education still today is not recognized as a fundamental right in this country and is mostly viewed, legally viewed, as a function of state and local governments. So let's go to the next slide and let's look how this intersects with affirmative action. In its history, affirmative action has both been praised and criticized as an answer to racial inequality. The term affirmative action was first introduced by President Kennedy in 1961 as a method of redressing discrimination that had persisted in spite of civil rights laws and constitutional guarantees. It was developed and enforced for the first time by President Johnson. He said the following: "This is the next and more profound stage of the battle for civil rights. We seek not just equally as a right and a theory, but equality as a fact and as a result." Focusing in particular on education and jobs, affirmative action policies required that active measures be taken to ensure that Black and other minority communities enjoyed the same opportunities for promotion, salary increases, career advancement, school admissions, scholarships, and financial aid that had been the nearly exclusive province of whites before. From the outset, affirmative action was envisioned as a temporary remedy that would end once there was, quote, a level playing field for all Americans. There are a number of important cases. They're on the screen here. I'll start with the Regents of the University of California versus Bekah. That was in 1978. It established the constitutionality of affirmative action programs. The Supreme Court had considered in that case a quota system in place at the University of California. At the time, UC Davis reserved 16 out of every 100 spots for qualified minority students. Alan Bekah, a white man, was denied admission by the university's medical school despite having higher test scores than minority students who were admitted that year, and he decided to sue. In Bekah, the court decided that the quota system was unconstitutional, along with the use of affirmative action policies to remedy the effects of racial discrimination. But in a narrow majority, the court also ruled that schools did have a, quote, compelling interest in the educational benefits of having a diverse student body, which allowed them to consider race in admissions, so long as it was one of many factors considered. In the words of Justice Powell, quote, race or ethnic background may be deemed a plus in a particular applicant's file. I'll now take up the Grutter versus Bollinger and Gratz versus Bollinger from 2003, big fast forward. This pair of decisions, especially the Grutter case, laid out the blueprint for race-conscious admissions that's been widely used by universities since. Both lawsuits were brought by white individuals who were denied admission to the University of Michigan. In Gratz versus Bollinger, Jennifer Gratz and Patrick Hamaker sued over a points-based admissions system used by the university. At the time, the University of Michigan granted admission to any applicant who scored more than 100 points on a 150-point scale. Members of underrepresented minorities were each granted 20 points. And as a result, quote, virtually every, their words, qualified applicant from these minority groups was admitted. This is that plus factor I referenced a second ago. The court found, though, that the point system itself was unconstitutional because race had not been considered on an individualized basis. But in the Gratz case, the companion case, Grutter brought by Barbara Grutter over her denial from the university's law school, the court upheld the basic concept of affirmative action. Admissions officers could consider the race of applicants so long as they did so in a, quote, narrowly tailored and individualized way, different than the point system just outlined. This was found in a 5-4 majority. Notably, in Grutter, the court also said that race-conscious programs should not exist permanently. Writing for the majority, conservative Justice Sandra Day O'Connor expressed the expectation that, quote, that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. This is significant for some who believe that put an expiration date on the use of affirmative action as we knew it. In the Fisher cases, we see affirmative action come before the Supreme Court again. After being denied to the University of Texas in 2008, a white woman named Abigail Fisher sued the university over its race-conscious admissions policy in what was widely seen as an attempt to overturn the court's previous stances on affirmative action. At the time of her lawsuit, the University of Texas automatically admitted Texas applicants who had completed high school in their top 10% of their graduating class, regardless of their race. For the remaining spots in each incoming class, about a quarter of admissions, the university considered a wide variety of factors, including race. Fisher challenged only this discretionary part of the Texas admissions policy. When it first heard the case in 2013, the Supreme Court actually sent it back to the lower court. Then in 2016, the justices ruled in favor of the university, finding that its admissions program was in fact constitutional. Although Justice Kennedy ultimately voted to uphold the Texas admissions policy, he also wrote in the 2013 decision that universities must demonstrate, quote, before turning to racial classifications, that available, workable, racial neutral alternatives do not suffice. And that leads us to the next slide and the SFF cases. Here, the Supreme Court again ruled in a set of affirmative action cases. This time they came out of Harvard and the University of North Carolina, looking more closely at their affirmative action programs and admissions. However, the court's ruling here still allows colleges to consider how race has affected a student's life and their ability to contribute to the educational institution, not just race itself. But the decision also did make clear that affirmative action programs, as we knew them, violated the Equal Protection Clause of the 14th Amendment. The court's decision is really contrary to the 45 years of precedent that I just outlined for you. Bekah, Grutter, Fisher, and Gratz. Roberts concluded in his majority opinion that, quote, eliminating racial discrimination means eliminating all of it. Joined by Justices Thomas, Alito, Gorsuch, Kavanaugh, and Coney Barrett, he offered three primary reasons for ruling against Harvard's and UNC's programs. Those reasons are the following. They lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employing race in a negative manner involving racial stereotyping, and lacking meaningful endpoints. I want to take a second and kind of break down those three reasons. With the first, since racial classifications are inherently suspect and must be given strict scrutiny, the compelling interest claimed by the institutions and the means of accomplishing them have to be measurable. Harvard's and UNC's goals, according to Roberts, were, quote, commendable, but inherently, quote, elusive and imprecise. On the second point, Roberts said that the court had previously ruled that race could never be used as a negative factor in evaluating a student for admission. Both Harvard's and UNC's admissions programs did so, according to the majority of the court, effectively penalizing students who were not Black or Hispanic. Perhaps most important, though, it's difficult to see how any use of race in admissions could survive, as admissions is, as Roberts pointed out, a zero-sum game. If it's used as a plus factor that leads to one student being admitted, his argument is that someone else who is not admitted because they do not have the plus factor inevitably. Even though the court did not explicitly declare that it was overturning the Grutter case, which said that diversity was a compelling interest justifying the use of race admissions, that opinion does seem to be overturned, at least in fact. The court's third reason, though, might have been its most important. Roberts pointed out the court had clearly indicated in Grutter that affirmative action must have an endpoint. Recall Sandra Day O'Connor's 25-year clock. At oral argument, a couple of the conservative judges did appear, though, sympathetic to the idea that universities should have some flexibility to bring the use of racial preferences to a close on their own if they could point to a reasonable timeframe for doing so. But the message the majority ultimately took from Harvard and UNC through oral arguments and briefing was that there wasn't a clear timeframe, and that these institutions and others around the country could not be trusted to work toward eliminating racial preferences on their own, saying there is no reason to believe that respondents will, even acting in good faith, comply with the Equal Protection Clause anytime soon. The majority also appeared concerned that colleges and universities deeply committed to racial preferences would try to evade their ruling by adopting facially neutral admissions policies that nevertheless had a discriminatory effect. Much of the court's reasoning seemed designed to warn universities that engaging in various evasions would only put them in more legal jeopardy. Roberts said in the decision, universities may not simply establish through application essays or other means the regime we hold unlawful today. He said further that the ruling does not prohibit, though, quote, universities from considering an applicant's discussion of how race affected their life, but then gave specific examples of how that must be done. As one example, he says, a benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal must be tied to that student's unique ability to contribute to the university. The three members of the court's current liberal bloc, Justices Sotomayor, Kagan, and Jackson, dissented. Jackson offered a separate dissent since she had recused herself from the Harvard case in light of her service on Harvard's Board of Overseers. Sotomayor, joined by Kagan and Jackson, accused the majority of, quote, rolling back decades of precedent and momentous progress. In a biting dissent, Jackson said the majority's opinion suffered from a, quote, let them eat cake obliviousness that disregarded the ways race still matter in American life. This point resonates with me personally, as we know the Supreme Court has affirmatively deemed unequal funding, as I talked about in the San Antonio case, in our K-12 system as constitutional and not attached to a fundamental right, a right to education in our country. I'm personally left after this decision wondering if affirmative action is not the legal means to addressing these inequalities. What is? Post the SFFA case, the Department of Education has taken two significant steps that I'll highlight briefly. First, it is investigating Harvard's legacy admissions policies. This is significant not just for those that are admissions practitioners in the webinar, but I think this is significant as a matter of educational law and constitutional law more broadly. I'm not sure that the Supreme Court intended to make a strike at legacy admissions through this decision. Second, the Department of Education and the Department of Justice have issued joint guidance to institutions of higher education about this decision. The guidance states that the SFFA decision prohibits race in and of itself from being a factor in admissions decision, but that institutions may still use holistic application review processes and consider how applicants' individual backgrounds and attributes, including those related to their race, experiences of racial discrimination, or the racial composition of their neighborhoods and schools, position them to contribute to campus in unique ways. The guidance emphasizes, however, that admissions decisions must be based on, quote, that student's particular qualities as an individual versus experiences or background factors that may apply to a demographic group generally, and not be on the basis of race alone. The guidance clarifies that institutions of higher education may continue to have missions and goals tied to student body diversity and may use all legally permissible methods to achieve that diversity. The guidance notes that the SFFA decision did not specifically address steps institutions may take to achieve diversity, but describes how the federal government believes several existing practices may be lawfully used to achieve such purposes. Areas of guidance include targeted outreach, recruitment, and pathway programs, the collection of demographic data, the evaluation of admissions policies, and student yield and retention strategy programs. In conclusion, looking ahead, our institutions will need to be creative, mindful, and resourceful in the legally permitted areas of our operations. But we also need to remain committed and undeterred in our desire to create access to legal education for all. As individuals, we also need to motivate our communities to vote. As I fear the current guidance provided by the current administration on SFFA may suffer the same back and forth experienced in the Title IX guidance when federal administrations changed leadership and parties. We want the space and opportunities that legally remain to exist well beyond these early days post this case. Thank you.
Thank you, Dean Dodge. We will now ask Mr. Austin to come forward at this time.
Thank you so much. Good day, everyone. My task here is to really level set the conversation by providing a viewpoint, particularly from LSAC. Recognize those of you who've attended law school who are in this webinar may be familiar with the organization in many ways. And of course, my admission profession colleagues and others in the space are. But let me talk about the things that LSAC has been doing and will continue to do both pre-SCOTUS and post-SCOTUS. Next slide, please. So the LSAC has long centered its mission, and I like to repeat this for everyone because it's often lost as people think only about the LSAT. LSAC's mission is to advance law and justice by encouraging diverse, talented individuals to study law and by supporting their enrollment and learning journeys from pre-law through the practice. So everything that the organization does is centered around access and diversity. Next slide. So, and keep going, thanks. So what I thought I would do is offer some data and spotlight some information. So again, to kind of put everyone in the mind frame of where this conversation has been and where it's going. So I call this the next few slides, looking back 2015 and looking ahead 2023. So this slide represents the fall 2022 entering class across the country. And as you can see, the colors going right to left recognize from 2018 to the current, for the last fall entering class of 2022. We won't have 2023 data just yet because, as you know, the class has just entered. But you can see the growth in this trend here of people who identify with racial or ethnic self-identity of the students who've entered over the last 5 years. It's been a substantial upward trend over time. I'll point out 2021 was an unusual year, as we all know, with COVID. There was a surge of interest in the law stemming from the long overdue racial reckoning with the murder of George Floyd and many other factors. And so there are some folks who thought, well, that's a one-off. What's going to happen with the class of 2022, and particularly with the pool of diverse candidates? Well, you can see 2022, we saw another huge advance in the enrollment of students of color. And actually, the overall percentage again trended up to 39%. The percentage of women, again, has trended up to 56% for 2022 and having substantially moved forward over the last 5 years. And finally, one of the things I'd like to point out that of the folks who entered law school in 2022, 98% use the LSAT. And that number has been consistent across all demographic groups. So we see the surge of increase with, in racial and ethnic identities being matriculating into law schools, and the vast majority with great confidence took the LSAT. Next slide, please. So this next slide is, it's pretty dense, but hopefully I can walk you through it. So it's the applicants, the total applicants to all the US ABA accredited law schools for the 2019 to the 2023 cycle. This is a snapshot as of July 9th. As I indicated, we don't have and won't have the final fall enrollment for fall 2023 and probably until late this fall. But again, the trends here. The line in the middle is that red line, and I apologize if it's not accessible to everyone. The red line is in the middle is this year. The blue is last year, and the green is the off the charts 2021. There's an orange and purple lines there that are 2019 and 2022. So what we're seeing here again is the number of applicants to the nation's law schools really mirroring what occurred in prior years. And so on some level, internally, we've talked about this class of 2023 applicant cycle returning to what we may consider normalcy in terms of just the overall percentage of candidates. Next slide, please. So this slide is a slide of again, it represents the year-to-date total applicants for the last 5 years, and the percentage of those applicants who self-identified as students of color. And you know, the ability to self-identify is really left up to the candidates as they submit their material to us and lead forward on to the schools. So the key takeaways from this is that though the number of applicants for 2023, which is the bar to the far right, is slightly lower, the proportion of applicants who self-identify as racial and ethnic diverse is up 1.4% from last year's record. So you can see again, the line that permeates across the years is an upward trend. And it represents, I mean, this last entering class for 2023, as of our snapshot date at the end of August for this one, 47%, actually 46.9% of the students who applied to law schools identified as people of color. The gender identity for 2023, that is applicants who identified as women, is also an upward track. They represent 56.6% of all applicants, which was compared to 54% back in 2019. And what we're also seeing is those who identify as gender diverse, while it is still a relatively small, and that is the very top of the bars, the little thin purple lines up there. And you can see, though it's a relatively small, it's been steadily increasing dramatically. It represents 1.3% of applicants in 2023 versus 0.5% in 2019. So what are we doing, LSAC? What are we doing in terms of assisting schools and also assisting students? So let me talk a little bit about this. LSAC has long supported member schools, and we have 190 of them, and will continue to be the innovative, trusted partner. We are clear that we don't offer or provide legal advice. We just are the partner in this journey. So how are we helping schools particularly? Well, we're actively helping schools to prepare. We prepare in advance and even in the aftermath of the decision. We call these learning opportunities. Last year, we started monthly webinars on various topics, including how LSAC provides expansive options to schools to craft their individual admissions applications. We call those the Flex app. For example, let's say if a school seeks to add additional personal statement prompts or understand how to manage the data platform to suppress any demographic information as to be in compliance with the decision, you know, we are assisting them in walking them through those steps. We have continued to provide opportunities for law schools admission professionals to hear from colleagues in states that have operated under voter initiatives banning the use of race in admissions, and some of those colleagues represent schools from California, Texas, and Michigan. We've also included some conversations with undergraduate schools, admissions professionals in those states as well. One recent webinar that I curated and hosted was an opportunity for member schools to hear from law schools in the New York City area and in Delaware that have removed the criminal history inquiries on their application. You may wonder why might that be important? Again, the criminal history inquiries on various applications may be seen as obstacles and offering more of inequalities and inequities in terms of applying to the various schools. And finally, we hosted a post-decision hybrid workshop in DC with a panel of experts to unpack its decision. One of our major products is a resource hub web page. It's called The Future of Admissions, The Future of Law School Admissions. And there we recently added documents issued jointly by the Department of Ed and the Department of Justice, those guidance memos that my colleague Dean Dodge mentioned. And then finally, DEI pipeline grants. We continue to award law schools whose programming promotes access and equality in legal education and profession. Those grants are mainly in support of law schools who operate summer or academic year programs for undergraduate students who are thinking about law. And then finally, this is an exciting new collaboration we've entered, the environmental context factors. So in collaboration with the College Board, the folks who do the SAT, our research team is exploring what we call relevant environmental context factors and how to operationalize that research for use by law schools. So what do I mean by that? So we talk about law schools considering the whole person in a holistic review. Well, we know the social, educational, and cultural environment in which applicants live and learn is a critical piece of their lived narrative. The College Board has been offering for undergraduate schools a product called Landscape, which enables their undergrad admissions officers to go in and understand what the particular educational environment was like for the student at their high school, whether they're AP courses, what the Pell Grant community is like, and others. So it may not be the same theory and practice that we develop for legal education, but it's proving to be very promising, and we look forward to that work coming forward. Next slide. So assisting students, because so much of our mission is not just assisting member schools, it's also being the source of information for students. So we have stepped up our intentional digital advertising, specifically aimed to recruit students of color and encourage their attendance at one of our free national LSAC law school forums that we host around the country, where over 150 schools are in attendance. Those are run from New York to San Francisco to LA, Miami, Chicago, Boston, very large, robust events every year. We also host increasing the number of virtual recruiting events that we do. Those came out of COVID, but we've decided we're continuing those and increasing more of those. Plus programs, pre-law undergraduate scholarship programs. You heard mention of the program that Penn State has run there in partnership with CLEO. Well, now for over 20 years, LSAC has continued to support traditional summer programs. And now we look to reimagine Plus and call it Plus at Scale to increase the participation from more schools and thus impacting more undergraduate students. The LSAC fee waiver. This is a legacy program that is designed for financially under-resourced applicants, recognizing the different levels of financial need. Last year, we expanded eligibility so that, in fact, 72% more qualified. In fact, 70% of the fee waivers were awarded to applicants of color. So having a fee waiver can make a huge difference for a candidate, because the fee waiver applies not only for the test itself, for the practice exams, and for your application to various law schools. So in the fall of 2022, more than 2,400 entering students received an LSAC fee waiver. Writing for impact. We've heard that SCOTUS specifically says that the decision specifically says that schools can consider student statements of how their experiences of race have shaped them or shaped what they bring to the institution. So we want to help students, especially students of color, be better writers, be thinking about what it means to put your narrative to paper. So we want students to be able to present themselves in the most authentic and compelling manner. So last summer, we had a pilot program that started with 2,000 students. We're hoping to have 3,000 students this year. And it is a hybrid program with coaches that we have put together to assist students to begin to think about crafting their personal statements and their narratives. I mean, one thing I heard for so many decades as an admissions professional is, I don't know what to say. I don't know what to do in my personal statement. Well, we understand now this is becoming even more critical, and we've stepped into this space to offer some guidance and work in that. And then finally, we have Law Ready, which is a partnership with several undergraduate schools. And it's a bold new initiative where students develop a roadmap in terms of their existing academic courses that are aligned towards their major and graduation requirements to skills and abilities critical for law school. So we're rolling that out this year, we have a partnership of about 5 undergraduate schools working closely with the academic advisors, the vice presidents of academic affairs on those campuses to identify students who are thinking about law school and what courses within their existing curriculum will help them develop the kind of critical thinking skills, analysis skills that would be useful for law school. So my last slide, please. So in our view, I think the view for many of our member schools, the SCOTUS decision is only a headwind that will make enrolling a class that looks like society harder. But it just means, and even as Dean Dodge noted, we just need to think long-term and be innovative in our recruiting, our application process, a vigorous review process, and what it means to the entire ecosystem of legal education. We know that we've been hearing from schools that one of the worries is that, will this decision be a signal to students of color that they are no longer welcome in higher education, that the cards are even further stacked against them, or that they should set their sights lower? What should we say to all of this? Again, we need to redouble our efforts to recruit all students, and especially students who remain underrepresented in law school classrooms. Make it clear that they are welcome, they belong, and we need to sustain a campus climate that enables all students to survive and thrive. LSAC and RISE Alliance will continue to be a partner to all member schools with innovative services and programs that encourage and support prospective law school candidates. Thank you very much.
Thank you, Jay. We'll ask Dean Saidman-Krauss to come forward.
Thank you, Associate Dean Dodge, for that excellent constitutional law overview, and Executive Director Austin for offering insight into the Law School Admission Council's mission and the ways that LSAC offers support and resources to both law schools and law school candidates. The two of you have really teed me up nicely for the continuation of this conversation. And so now I would like to turn our attention to the practical implications of these decisions. What do the Harvard and UNC cases mean in practice right now for law school admissions officers? And the answer, as it often is in the context of law school, is that it depends, right? It depends on how admissions offices were evaluating applications prior to the Harvard and UNC decisions. It depends on what race and ethnicity information admissions offices were collecting, how that information was being used, and who could access it. And of course, it depends on leadership, both in terms of how comfortable your dean or president or provost is with actual or perceived risk, and what their vision for the future of your institution is. So at the outset, I think it's important to remember that, as Dean Conway has had to remind me more than once since June 29th, the Supreme Court's holdings in these cases are narrow in their scope, in that the court was assessing the constitutionality of the specific undergraduate admissions programs at Harvard and UNC. And when I start catastrophizing about the future of race-conscious admissions, I remind myself that Justice Robert explicitly acknowledged in the court's opinion, we are not prohibited from considering an applicant's discussion of how race has affected their life. So with this framework in mind, I want to return to the question of what do the Harvard and UNC decisions mean for us, practically speaking. And to do this, I'm going to walk you through some of the changes that Dickinson Law has and hasn't made in light of these decisions. Next slide, please. Let's start with what hasn't changed. Our commitment to holistic application review to identify candidates who possess the skills to succeed in our program of legal education, alongside values that align with Dickinson Law's commitment to institutional anti-racism geared to fulfilling the promise of equal justice under law. Now let's talk about what has changed. And note that I'm using the word changed pretty liberally here. Frankly, the word tweaked might be better suited. First, I'll discuss our collection and use of checkbox data with respect to race and ethnicity. Then I'll talk about a new optional statement that we've added to our application. Before June 29th, 2023, Dickinson Law collected what folks would refer to as race and ethnicity checkbox data on our application. Responses to the race and ethnicity checkbox question remained visible throughout the review process as part of the candidate's application and applicant record. Dickinson Law used this data to regularly assess and analyze, in the aggregate, the demographic composition of the candidate pool vis-a-vis school-specific point-in-time historic applicant pool data, as well as current year and prior year national applicant pool data that LSAC generously provides to law schools. It's worth noting that Dickinson Law's data reports included myriad other categories beyond just race and ethnicity, including prior or current military service, identity as a first-generation college or graduate student, permanent state of residency, identity as a member of the LGBTQ+ community, whether the candidate used Pell Grants to help pay for college, whether the candidate was raised in a rurally isolated area, and so on. Dickinson Law has been collecting a wide swath of demographic data for years. These data points are tools, albeit imperfect tools, to analyze and compare candidate pool composition. Admittedly, a checkbox approach to collecting race and ethnicity data has its limitations. Indeed, the very nature of checking a box deprives candidates of sharing nuance related to the way they experience their multidimensional and intersectional identities. But for the purpose of high-level aggregate data analysis, a checkbox approach has some utility. Here's one real-life example. A few years ago, as part of our effort to identify admissions practices that resulted in disparate outcomes or inequity with respect to race and ethnicity, the admissions and financial aid team at Dickinson Law closely examined our historic scholarship data. Our assessment revealed that on average, white students received higher merit awards as compared to students of color. Seeing this variation borne out in the data helped our team adjust our approach. We realized that we had been relying more heavily on quantitative aspects of our holistic review as compared to qualitative measures of success. So over the past several years, Dickinson Law has intentionally endeavored to close the gap between the average institutional scholarship offered to students from minoritized racial and ethnic backgrounds as compared with white students. We've adjusted our approach to awarding by placing greater emphasis on qualitative aspects of our holistic review and by considering an applicant's successes relative to the personal challenges they have faced. In our 2021 article, Building an Anti-Racist Law School, Leadership Determines DEI Success in the Admission and Retention of Diverse Students, Dean Conway, Bekah Schreiber, and I discuss this example in more detail, and we identify other ways that we have used historic aggregate race and ethnicity checkbox data to identify and ameliorate systemic racial inequity. As a law school committed to anti-racism, Dickinson Law will continue to collect race and ethnicity checkbox data, not so that we can admit or deny a candidate because of which box they check, but so that we can conduct rigorous data analysis to understand applicant trends and how those trends relate to our educational mission. After all, how can we engage in dismantling systemic racial inequality and measure our success if we're not collecting data on race? But to avoid the appearance of improper use of race and ethnicity data, we have updated our user settings within our application database run by LSAC so that individual file reviewers are not able to see a candidate's response to the checkbox race and ethnicity questions. Our in-house data expert, Bekah Schreiber, will continue to run reports on all demographic categories that we track except for race and ethnicity. Out of an abundance of caution, Dickinson Law has bifurcated the race and ethnicity component from our in-house data reporting and analysis. we have requested that another unit within the university, Penn State's Office of Planning, Assessment, and Institutional Research, assist us by generating these reports on our behalf in accordance with our desired parameters and formatting. As has been our custom and practice during each admission cycle, Dickinson Law will continue to analyze aggregate applicant pool data to conduct year-over-year historic comparisons and to make informed enrollment projections throughout the cycle consistent with Penn State's land-grant mission. We plan to continue to engage in this legally permissible practice, but with some safeguards in place to avoid the appearance of any improper use of race or ethnicity data. And finally, I mentioned earlier that leadership, or more specifically, a leader's vision for the institution's future, is one of the variables that may inform how a particular admissions office responds to the Harvard and UNC decisions. Under the deanship of Danielle Conway, Penn State Dickinson Law has emerged as a leader in anti-racist legal education. Dickinson Law, the first law school in the Commonwealth of Pennsylvania, a law school that was founded in 1834, literally before the 14th Amendment was even ratified, has embraced anti-racist law school administration and anti-racist legal pedagogy. It makes sense, of course, that we should offer candidates the opportunity on our application to discuss how they will advance Dickinson Law's anti-racism work by drawing upon their lived experiences, equity mindsets, or actions that they've undertaken to promote inclusion and belonging, justice, or anti-racism. And so we have added this prompt as an optional statement that we encourage candidates to submit. Responses to this prompt become part of the candidate's application and are evaluated as part of our holistic review process. And by the way, this new prompt, which is both precise in its language, that is tied to our anti-racism work, and broad in terms of the ways that candidates can respond, has replaced our prior optional statement on diversity. I'm proud to share that this prompt was collectively edited by Dean Conway, Laura Williams, our Associate Dean of Administration, Rebecca Schreiber, Director of Admissions and Financial Aid, and me in my capacity as Associate Dean for Admissions and Financial Aid. This is how leadership shapes the impact of these decisions. The substance of this prompt reflects Dean Conway's leadership in advancing anti-racism work at Dickinson Law, and the form, the actual crafting of this question, reflects Dean Conway's inclusive and collaborative leadership style. I want to conclude by noting that Dickinson Law's newest cohort of 1Ls started classes earlier this week as our fall semester began on Monday. Nearly 47% of students in Dickinson Law's class of 2026 identify as students of color. Not because Dickinson Law is admitting folks based on their race, but rather because we are engaging in holistic applicant review. And we remain committed to this practice even and especially in the aftermath of the Harvard and UNC decisions.
Thank you, Dean Saidman-Krauss. We'll ask Professor Fair to come forward, and I will ask you to unmute, and I will stop sharing my screen.
Thank you. Good afternoon, everyone. I'm thrilled to join friends and colleagues who've been in this work for decades. I appreciate so much the work at ADI and Dickinson. Of course, Jay's work at LSAC is legendary and so important in this critical time. This is my first time meeting Bekah and Jeffrey. To each of you, I thank you for your presentations, your excellent presentations as well. Tawanda, I was so grateful that you started by acknowledging the trials and tribulations, the failures of our nation from its founding. Too often we don't in these discussions around race or inequality. We don't remember Indigenous people in this country. We don't remember immigrant groups in this country and the struggles they've had. Too often we think about race and write about race as a black-white binary. And And I think in this instance, in this context, when we think about access to universities, we don't want to just think about race, because what the court has said about race may be extended to other impacted groups through our history. And I'm certainly thinking about that. So Tawanda, I appreciate your beginning and the framework that you provided us. I'm often, for the past 40 years, I've been thinking about inequality in the United States, and I've made it my life mission to understand more fully how a nation supposedly founded on principles of equality could have so much inequality in education, in housing, and employment in our society. We are often taught to believe that the arc of the moral universe bends towards justice. But I don't believe that, because for all of us who are doing this work, and I don't know all who's on the webinar today, but for all of us who are committed to justice and access to improving the opportunities of underrepresented people and minorities, poor, racial minorities, and otherwise, there are as many, if not more, people working against us, including the Supreme Court of the United States, at least a majority of the Supreme Court of the United States. So I say today that we have to bend the arc of the moral universe in the way that Jeffrey and Jay and Bekah and Tawanda have described. Those of us who want to have inclusive places of education, who want to see diverse students enroll, and not just enroll, but thrive in our environments. We have to be there for them. We have to be their champions. We have to fight every day against those who take the view of the U.S. Supreme Court that our Constitution is colorblind. We have a 400-year history in this country, and there is no period in this country's history that has been colorblind. It is laughable for the Supreme Court of the United States to say in 2023 that the proper interpretation of the Equal Protection Clause is colorblindness. That's not what the framers of the 14th Amendment said. That's not what the original interpreters of the 14th Amendment said in the Slaughterhouse cases or otherwise. In fact, Charles Sumner said the purpose of the 14th Amendment was to eliminate black caste. It's appropriate to critique that we should be eliminating all forms of caste via the 14th Amendment in the United States. But to adopt as the controlling doctrine for the country in 2023, having ignored that principle for 150 years, is outrageous. It's hypocrisy of the highest. Others have said that they are here on behalf of institutions or organizations. I should say that I'm here today on my own behalf. I'm not speaking on behalf of the admissions office at the university, the dean's office at the University of Alabama, the University of Alabama more generally, the system office, university council, or otherwise. I'm here in my role as someone who's been interested in law school admissions since the time I first applied as a diversity admissions candidate at UCLA. I benefited personally from the Bekah decision, both in my enrollment at Duke University as an undergraduate student, and then my enrollment at UCLA through its diversity program as a law student. And I would never roll back the programs and policies that lifted me up out of poverty, that gave me an opportunity to change my life and to change the life of my daughter and my family members. But that's what the court is doing today. With its decision in SFFA, I think it is more than just a headwind. I think it is an attempt, I believe, to close doors in fundamental ways. I don't think that most law schools in the country are going to do, Bekah, what Dickinson and what Dean Conway are doing, what your team at Dickinson are doing. I don't think that your model will necessarily be the model. I don't have confidence, for example, that will be the model at my own law school. I'm in Alabama. And I don't think this will just be an Alabama response. I think there will be responses in red states across the country, and there are many of them, that take the words of the Supreme Court's decision and largely ignore, Jeffrey, the federal advisories provided by the Justice Department or the Office of Civil Rights in the Department of Education. I imagine that for some, this will be a way to actually assert that law school admissions must indeed be race blind, and only in a matter of time whether there will also be a policy around gender blindness or blindness relative to other kinds of factors, including gender identity, some of the issues that Jay spoke of. So I think that this is a critically important time, and for me, a very unhappy time in our constitutional history. The remedial affirmative action policies that Dean Dodge so carefully described through the Bekah and up to the Fisher decisions, I think was excellent and helpful for anyone, I think, interested in what's happened. I think that the new decision, in fact, overrules the Bekah decision. It overrules Gruder's embrace of Bekah and the power of universities to seek the educational benefits of diversity by using race, at least, as a factor of a factor of a factor. And all the cautionary language that Chief Justice Roberts includes in his opinion about institutions not doing indirectly what the court has prohibited directly, I think those are real threats that you can be sure Ed Bloom and others at SFFA are going to take seriously. And I think there will be challenges to all the different ways we might try to continue to enroll diverse student populations. I think this is just the tip of the iceberg. And I think these threats are real and that we need to think about them that way. So for me, again, this is a very unhappy time in our constitutional history. It's not the first time I've been unhappy about our constitutional history. In that way, I agree with all the other panelists who've said we are up against a fight. We are up against a clear fight if we hope to see the numbers of minority and underrepresented students remain on the upward trajectory that Jay described from the tables at LSAC. I said that I would make most of my remarks about how I will advise students. I have, for the past 35 years, I've used a document called Preparing for a Career in Law in the 21st Century. A document I first wrote when I was at UCLA, and I've updated it every couple of years. I've updated it this summer and working on the final updates, and we'll make some additional edits after today's webinar. In that document, I offer to counsel and mentor any student who finds the document online. I invite them to call me. I invite them to, after reading the document, which is only about 15 or 20 pages, to call me and ask me specific questions about the admissions process. I'm not currently on our admissions committee, but I've served in the past. I don't work with, obviously, just with Alabama students. I try to work with students from around the country who are seeking to enroll in law school. I have borrowed heavily from the Law School Admissions Council, from the Khan Academy, from Clio, from other resources that are out there in preparing this document, Preparing for a Career in Law. If you Google that title, anyone on the webinar who Googles that title will find a 2021 version of the article, but within a week or so, a 2023 version will be available that specifically addresses the Supreme Court's decision in June, my reading of that decision, and what I think it means for admissions. What I think it means for admissions is that admissions offices will, in fact, change their applications. I think they will change their admissions procedures. I think they will change what readers have access to. The role of readers, I think, will change, and there will be probably greater demand for more readers, especially as the personal statement becomes more important in the way that Jay described. I have told students for decades that the two most important factors in law school admissions are the LSAT and the undergraduate GPA, that most schools admit students primarily on those two variables. Given the opinion, given the majority opinion in this summer's decision, I think the personal statement will become the third most important factor. And that writing that statement in the way that Jay described will become critically important to the admission of many minority students and historically underrepresented students who at many schools, especially the most selective schools in the country, don't have the traditional numeric profiles that particular schools seek. At Alabama, there's an effort to maintain or raise a profile of a 165 and a 394. And I've said to my colleagues that every time we raise that profile, we effectively exclude historically underrepresented minority students and other historically underrepresented students. I see no effort by the most selective schools in the country to relax those numeric standards. So readers then are going to have to find additional students through the personal essay. I think the Roberts opinion essentially says that law schools or universities can admit students based on challenges bested, obstacles overcome, based on lessons learned, skills acquired that have influenced in the way that Dean Dodge described one's character, one's ability to contribute to the intellectual diversity of the law school community, or to contribute generally to the law school. Those are generalizations. And I want law school applications to tell students that they can affirmatively describe their life journeys and the various kinds of obstacles that one might overcome, whether it's as a first-generation student, whether it's as a child of a single parent, whether it's as someone who has a different gender identity, whether it's someone who's experienced exclusion on some ground. I'm not, in my revision of preparing for a career in law, limiting my thoughts about the personal statement just to descriptions of race, racism, or experiences of racial exclusion. Even though I'm encouraging everyone who reads my piece, especially minority students, to talk about their race journey, whether it's an immigrant journey, whether it's a journey about the conquest of people in the way that Wanda was describing of indigenous people, whether it's a story of racial discrimination, racial isolation. I think only by doing so will readers know whether a particular applicant is a student of color. If that data, if the check the box data is not available to readers, if it's not available to the person making admissions decisions, if that's the structure that the court has given us, unless the student himself, herself, or they provide that information to readers, then these decisions are going to be made in a so-called neutral way, and critical information will be absent from the kind of holistic review that I think Bekah and Dickinson, folks at Dickinson, are describing as part of their anti-racist mission. So I'm describing a new adversity test. I'm telling people that I speak with that schools can take into account the adversity that you've experienced in your life, but they're only going to know about that if you write about it, and you write about it in a clear, succinct 2 to 3 page essay. So I'm delighted to hear that LSAC is pioneering some new programs, Jay, and I hope that all of us who are doing mentoring, who are reading personal statements, will build on that work and help students understand the kinds of adversity stories that they might tell. Because students might write about anything, and unless we give them clear instruction and clear direction, some people that might very well thrive in law school, we're not going to know about them. We're not going to know about their stories unless they know the kind of story that they need to tell, and that will be sufficiently distinct and individual to capture the attention of a reader. So again, the first generation story, the sort of longstanding educational disadvantage that so many people in this country still experience. And not just people of color, lots of people in this country go to school in a rigged system that devalues their education, devalues them. And so some people write about that. I certainly believe that racism is alive and well in the United States, that we have never become a post-racial society. So I'm encouraging students to write about race. But again, I think gender, many people experience this country through a gendered lens, not a racial lens, or through both. And so some people might tell an intersectional story, a multi-layered story about their journey. But I think it is incumbent on us who want to continue to see broad diversity in education generally, legal education for me specifically. We have to help them understand how to craft an application, notwithstanding limitations on demographic data today, that will enable readers to, on an individual basis, select out people because the story that they've told does tell something about their character, does say something about how they can contribute to our academic communities as we go forward. So I will stop there. I don't know where we are in our time. I appreciate the opportunity to share a few thoughts and look forward to hearing from all of you.
Thank you, Professor Fair, and I will invite all of our panelists to come on camera so that I can just make eye contact with them and thank them tremendously for their support and participation. Such a wealth of knowledge and information was shared with all of us today, and appreciate all that you have prepared and shared with us. I do have hope in light of all that was said here today, that in the weeks and months that follow from the decision, that we will indeed see a stronger, better, and more diverse group of individuals coming through all of the ranks of higher education. And it is in no doubt a reflection of the hard work that these folks, these professionals, and my dear colleagues have done in the days and weeks since the decision. So from my heart to yours, thank you all so much for all that you have done here today. A couple of real quick, brief announcements as we begin to leave this place. I do want to share a save the date for our next webinar in this series. Part 2 will be on Friday, December 1st, 2023, at a time to be determined. It will likely be around this noon time again. So please mark your calendars and more information will be forthcoming about that. In addition, the Antiracist Development Institute will have an inaugural convening, a 3-day event here on the campus of Penn State Dickinson Law. If you're able to snap a picture of that QR code, it should take you to our registration page. And we invite you all to register to attend and be excited about the things that we are doing here at Penn State Dickinson Law. Again, my name is Tawanda Hunter-Stallworth. It has been a pleasure to serve as your moderator today. We are grateful for all of our attendees who have come from near and far, from the inside of the academy, outside of the academy, inside the profession, outside of the profession. We are grateful that you have taken your time to be here with us today. Thank you again for your participation and have a great day.